invalidate any bit of EU legislation. All it could do is say this legislation is unlawful and therefore we're going to award monetary damages, but it wouldn't in itself stop the effectiveness of the legislation. So it's really quite similar to where you have a judgment from the European Court of Human Rights, for example, saying it's unlawful that in the UK prisoners don't have the vote. Well, prisoners still don't have the vote because our courts in England and Wales have taken a different view.
Yeah, I agree with that, but it's about extra contractual liability.
Is there time to fit in one last question? Anybody wishes to raise it? Yes, you have the microphone. We'd like to say who you are, where you're from.
Yes, I'm Ivana Dimitrova, and I did European Studies at the University of Hamburg. And I think Mr. Law mentioned the example of Vattenfall, and then I thought of the Germany nuclear power phase-out. And as far as I'm aware, Vattenfall and other energy companies are thinking of suing the German government for the nuclear phase-out. So my question, the first question goes to Mr. Bates. And legally, do you think that Vattenfall and the other energy companies are actually stand a chance of winning a potential court case? And to the other two speakers, do you think that ISDS could act as a deterrent for governments to adopt more ambitious environmental policies? Thank you.
Okay, I mean, I don't know what the prospects of success are in that case. Obviously, it's not a case under TTIP, and the question will be what assurances did the German government give to that company that its nuclear program would be maintained. So it's really a legitimate expectation type of case. I mean, I think this links into what I was saying about expropriation, that there could be an issue under TTIP as to whether or not a massive change of government policy that renders existing investments valueless is a form of expropriation. I think that's an issue that needs to be dealt with expressly in the drafting.
So the Vattenfall case, you didn't ask me if I think it will be successful. I'm not sure. I don't know. But in terms of, do I think that it can lead to governments thinking twice about future regulation, and even in the minutiae of how actually regulation is applied, because there's a big difference between you can create a regulation, but then actually the implementation of said regulation is actually up for grabs a lot of the time. Yes, I do, and I think you can see a lot of, I mean, so a recent case I can bring an example of. So I think it was last week or the week before, Canada again got sued under NAFTA under an ISDS clause, and it was because they wanted to, a company wanted to expand their mining operation into a zone that had environmental protection. I think they breed whales there. It's a whale breeding ground or something. And the government, Canada lost, and they were forced to pay money. But there's a dissenting view amongst the arbitrators, and they're actually in one of the more transparent panels. And he said that he's very worried that from now on this will make the Canadian government think twice about pursuing such measures. I mean, it's very clear to see how. And also, there's been a lot of talk about ISDS, it's there already. But I mean, why is it there already? You've got the examples from the past with developing world governments and why it might be necessary there. But in terms of the EU and US, is it? I mean, there's lots of other routes companies can take. For one, they can get insurance. They could buy insurance. They could have within the contracts themselves actual provisions to deal with it under contract dispute within the contract. So why is ISDS needed? It's not presumed to bring any economic benefit, any extra foreign direct investment. It just seems like another subsidy, as far as I'm concerned, or at least potential subsidy to government that mitigates risk for companies and puts it onto the electorate, because we pay and they are very expensive cases. So I have a lot of issues with it, actually, and I do think that it makes governments think twice. Maybe not the UK government, but also they can sue provinces. Hamburg was sued. If at the moment with fracking in the UK, it's actually the decisions on local government whether they want to ban it or not. Will a local government be so keen to take on one of these cases, knowing the cost? I would say that there is cause to think twice there, even if the national government itself might be bullish.
Final word, Amanda?
I would say that we certainly have to learn a lot more about specific ISDS cases, as Alan said. We need to know what certain contracts actually say that are brought to an ISDS case. But again, ISDS case can only be brought if there was a breach or if there was a discrimination. And this ISDS is an additional tool, but it is not that much different from, let's say, a tobacco company going to a local court in the UK and basically asking them to have a process over plain packaging.
It's completely different.
This is the worst part of being the chairman, calling a halt to a discussion which is going splendidly. But I'm conscious that we need to keep on top of this schedule. So I would like to thank the three presenters for getting today's conference off to an excellent start. Thank you very much.
Thank you.
Sam, would you like to come? I'm very conscious that TTIP raises a whole raft of issues, and they are being discussed at various points in the programme, and I was just hoping that the different presenters will be able to talk on their topic without too much of an overlap. So far, so good, but you will have noted from the earlier discussion that there are some constitutional issues, if I can categorise them in that way, relating to TTIP. And we're fortunate to have the next session, which will be given by Sam Fowles, who's a researcher on international law, Queen Mary University of London, as chair of the Rule of Law project, and he's currently conducting research on the constitutionality of TTIP, armed with an impressive academic background, degrees from various universities. I think he's very well placed to offer commentary on these issues. So, Sam, your talk is TTIP, Sovereignty and the Judiciary. Thanks very much. We'd like to come up here.
This. Okay, thank you.
If that confuses you, you can just use buttons.
Sure, thank you. Well, thank you very much for having me here. I must say I'm terribly glad that I get to speak from here rather than sitting on there, because I felt very lonely after we had three people before. As has been said, my principal research on TTIP has focused on the constitutional implications of it, but unfortunately, I can't actually reveal those my principal findings on that until the 24th of April, because they're embargoed until that point. Because it's a project funded by Mishcon de Reya, and they want to launch it. So if you would like to find out what I think about the constitutional implications, then come to a different conference. There will be free breakfast, which was important to me. However, I'm going to do my best to nevertheless provide you with some sort of original comment on TTIP. But it's going to be from a slightly wider perspective, and I've spent the last 3 months looking at TTIP, and it's involved meetings in Sydney, in Washington DC, and in New York, and in London. And one of the things I've noticed is that as lawyers, we tend to be a little bit like plumbers in that we like to fix the pipes. But my dad's a plumber, and so I know that there's no point fixing the pipes if the system doesn't work. And so I want to take a more sort of systemic approach and really answer the question that was asked at the end of the last session, do you think that TTIP and CETA, we mustn't forget that there's also a trade agreement signed with Canada along similar lines. Do I think that they will prevent governments from passing new environmental measures? And I think they absolutely will. And I'm going to talk about two concepts of how they might do that this morning. Two concepts of regulatory chill. The first is fairly established, which is legal regulatory chill, and The second is one that has come out of my research and I'd like to expand upon, which I call political regulatory chill. It's just worth recapping what exactly we're talking about. TTIP and CETA, I'm particularly interested in the investment protection provisions. And these provisions will prevent expropriation, mandate fair and equitable treatment, and ensure most favoured nation treatment. And most interestingly, they are to be enforced with a system of arbitration, investor-state dispute settlement. But it's also worth noting that if a state were to leave TTIP or CETA, these provisions will remain in place with regard to the investments made under it for 20 years after that. What does this mean for regulatory chill? Well, legal regulatory chill itself comes in two forms. The first is external, and that's very simple. A government passes a regulation and a company tries to get it overturned. And there's two examples I'd like to give you of this. The first is of Ethel and Canada. And this really gives a lie to the oft-heard statement that investment arbitration doesn't actually lead to changes in law, it just leads to compensation. In this case, Canada commissioned an independent study that said an additive known as MMT was dangerous when it was transported. So, relatively sensibly, they banned transport of this dangerous substance. This, unfortunately, compromised the interests of Ethel, which part of its business involved transporting fuel, including MMT additives, from the United States to Canada, and vice versa. And so they brought arbitration under Chapter 11. And it's important to note here that they weren't saying that Canada had taken their existing property. Canada wasn't charging them for all the fuel they'd already transported. This was about future profits. And Canada lost that case and not only had to pay $19 million in compensation, but in negotiating the compensation agreement, Canada also had to remove the regulation and make a public statement saying that the survey, conducted independently by scientists, was wrong. Another case is Deutsche Bank and Sri Lanka. And this doesn't actually concern a regulation, it concerns a decision of the Sri Lankan Supreme Court. And in that case, a third party brought a case to the Supreme Court arguing that Sri Lanka didn't have the power to enter into hedging agreements with Deutsche Bank. In considering this case, the Supreme Court issued an injunction suspending those hedging payments. Deutsche Bank then brought a case in arbitration against that decision of the Supreme Court, which was effectively overturned because Sri Lanka had to pay Deutsche Bank everything it would have paid them under the hedging agreements. And this is important because when we think about regulatory chill, we think about new regulation. But DV in Sri Lanka shows that in terms of current regulation, the Climate Change Act, the Clean Air Act, all of these, in terms of their enforcement by the courts, will be open to sanction through investment arbitration. Internal chill is a theory from a Canadian political scientist called John Benicia. And he postulates that government departments, in addition to having their decisions overturned in arbitration, or perhaps because their decisions have been in the past overturned in arbitration, simply then internalize that process and refrain from making those decisions. And Benicia cites Canada, which, let's remember, is a very rich country, not usually deterred by having to pay compensation. Canada considered tobacco plain packaging in 1994 and in 2001, and despite the overwhelming scientific evidence of its health benefits, elected not to pass this regulation. And Benicia presents evidence that this was because of threats of arbitration. A more direct threat of arbitration comes from mining in Indonesia's protected forests. Indonesia, when it was a dictatorship, issued contracts of work for mining. When a democratic government came to power, they wanted to protect certain forests. Mining companies wanted to continue mining in these forests that were protected. And bear in mind, this is open surface mining. The non-technical definition is digging a huge hole in a forest. So companies bought arbitration against the protection of these forests. And now, it's true, as Alan said, there are good cases and there are bad cases. This was a bad case. The contracts, I've got the notes on it here, legal advice on it. The contracts that the companies signed state that they must conform with existing law anyway. The law was proportional because it only prohibited surface mining. They could still dig a hole under the ground. All the contracts in the protected area were signed during an authoritarian government, not the democratic government that was now in power and had greater legitimacy. And Indonesia was bound by other treaties, international treaties, mandating they protect their environment. So this was not a good case. Nevertheless, it led to Indonesia essentially giving a pass to a certain number of mining companies. They then got extra protection with a presidential decree. And the Indonesian Supreme Court considered this decree. They weren't hugely in favour, but they accepted that Indonesia needed to develop a favourable investment climate. And so, despite there being a very strong case against this presidential decree, the Indonesian Supreme Court felt it had to give in to investors because of the further threat of arbitration. So this shows that ISDS doesn't even need to actually happen to have the effect of preventing environmental regulation. Will it have the same effect on the UK? As has been said, the UK has already signed up to over 100 bits, most of which include ISDS. However, there are two significant changes that come with TTIP and CETA. The first is a change of scale. TTIP and CETA will increase the coverage of investments by ISDS by 300%. And the second is a change in the nature of that which is covered. Most of the UK's bits are signed with states where the investment generally comes from the UK and goes to the state. They're not big providers of FDI. However, TTIP was signed with the United States, which happens to be consistently and by quite a degree the number one provider of FDI to the UK. CETA is signed with Canada, which is consistently in the top 5 according to Ernst & Young surveys of providers to the UK. So is this a significant change? Absolutely. Political regulatory chill is taking another step theoretically. Essentially it says, does the threat need to be explicit in order to prevent further regulation? And I don't think it does. If we accept that heads of governments abandon policies because of the threat of arbitration, there's actually further research that's been done by political scientists which suggests that arbitration can be a convenient excuse for policies that governments want to put into place but are unpopular, or to avoid putting in place policies that are popular but that governments don't really want to put in place. And my concept of political regulatory chill is when an international instrument prevents public debate, and it does this by embedding a certain viewpoint and gives it what is really an illegitimate authority. Now this is based on the theory of political cover from Todd Alley and Paul Huth that they published in the American Political Scientist. And they looked at trade negotiations, trade provisions that faced political opposition domestically and were settled with arbitration. And they found that governments found arbitration very convenient in order to avoid popular policies or put in place unpopular policies. And I asked, does the arbitration itself actually need to happen? Or is the simple threat or fear of arbitration enough to have the same political covert effect? And I think if we accept that governments abandon policies because of the threat of arbitration, as in the case of Indonesia, if we accept Benich's argument that they can abandon policies because of the fear of arbitration, as in the case of Canada, then it's logical to theorize that political parties can use the fear or the perceived threat of arbitration to argue against policies they don't like. But this isn't actually an argument. This isn't having a debate, this is killing a debate. Because rather than talking about the merits of the policies, the argument becomes, there's no point in talking about this because it might be illegal. And this is actually a very powerful argument because, believe it or not, most people that work in the environmental departments of governments, many people campaigning on environmental issues aren't international trade lawyers. And so most of the international trade lawyers tend to be in the international trade departments. And so it's a very easy case to make to say, I am in authority, I say this will be illegal. It's very difficult to argue against that. I want to illustrate this by sort of suggesting how it might tie into current discourse. It's a hugely powerful argument that's made against environmental regulation. Comes as part of this global race narrative that's used a lot. And it simply says that environmental regulation is an unaffordable luxury. But when we regulate, when we say that companies have to abide by certain standards in terms of the emissions they produce, in terms of what they do to the natural environment, or when we regulate to give an advantage to perhaps renewable energy. The argument that comes against this, that this is forming a drag on our economy. And I pulled up a few examples of this, just generally the power of the drag on the economy. The fear that capping fuel prices, the argument is that it may help, it may be a good policy, it may be popular, it may be democratically approved, but we shouldn't do it because it means that investors will leave. Yesterday's announcement about making non-DOMs pay tax was argued against because investors will leave. Scottish independence was going to cause investors to leave. So investors already wield a huge amount of power. If the very threat that they could go elsewhere, go to a supposed competitor state, causes arguments that we should drop primary legislation. That's already a huge power. This will add an additional power because after TTIP and CETA, they won't even need to leave. They will have a legal mechanism so that they don't have to make a sacrifice themselves. They don't have to give up the London lifestyle or the brilliantly situated city of London that happens to be able to trade with both sides of the world at the same time. They don't have to give that up to get their way. They simply have their own legal system they can do it through. And it shifts debate about environmental regulation from we cannot pass this policy because investors might go to China to we're legally prohibited from passing this policy. So shut up. Just in case anyone that doesn't believe that environmental regulation is seen as a drag on the economy and red tape, this is from the government's own website. This is the red tape challenge from the Cabinet Office, where you're encouraged to log on and decide what red tape you want to get rid of. And apparently that's every single environmental regulation ever passed is red tape. This is from the UKIP's website. And this is our former Environment Secretary. So to conclude this, what I've tried to do this morning has been to expand on the common understanding of regulatory chill. It's not just the regulation that becomes law that is threatened, but the policies that will never get a fair hearing ab initio. Of course, There are lots of factors that colour public debate, many that make public debate more difficult. But that's not a justification to adding to their number. The effects of legal regulatory chill have been pretty clearly elucidated by better minds than me. In proposing a second conception of regulatory chill, I've basically asked, is it necessary that the threat be explicit? And the work of Ali and Howarth demonstrates that governments wishing to pass unpopular policies prefer to use the political cover of arbitration, rather than simply owning the decision themselves and taking perhaps the electoral punishment. And it's a very small step to suggest that the cover generated by an arbitral decision could be similarly achieved simply by the fear of an arbitral decision. TTIP and CETA would make this much more probable, indeed, at least 300% more probable. And the effect will be to embed a discourse that says environmental regulations are a drag on the economy, and it embeds it by giving it legal standing. So a debate that balances the merits of regulation is replaced by a discourse which says there's no point in talking about it in the first place. As an academic, it's quite easy to be a disinterested observer about this. Perhaps I'm alone in finding that the trends of discourse fascinating, but nevertheless, I do. However, it's important to remember that this isn't just an academic question. This comes down to a question about when you cast your vote in 3 weeks' time, will it count? Will it count as much as someone else's? And as academics, or lawyers even, or anyone that attends this conference, we're in an incredibly privileged position because we get the time and the resources to consider these questions of public importance. But with that comes a responsibility to talk about them and to talk about them widely. I just want to finish with the thought that public debate is vital for democracy. It's vital for the future of environmental regulation, because public debate is something that those in favour of environmental regulation will eventually win. The economic, the practical, the moral arguments are overwhelming. Public debate is vital, and it's threatened by TTIP and CETA. I think it's worth defending. Thanks very much.
Thanks, Sam. It was chilling from start to finish, if not downright sinister at some points.
People say that about my conversation all the time.
If you thought there were reasons against environmental legislation before, it's going to get worse. Anybody can ask an optimistic question in response to that, or any question. There's time for a couple. The gentleman in the middle there would like to give you a name, affiliation.
James Hewitt. I work independently. I'm interested in introducing climate change into the discussion. We haven't really heard about it earlier. That does rather change the paradigm. There's an urgency which the politicians are ducking, and I believe they forfeit their right actually to represent the people.
I'm grateful for the question, but I just note there is a speech later on this afternoon which may well be covering some of that.
Okay, and economic growth does tend to accelerate climate change.
Mm-hmm. Okay, well, I'm not going to go into the science of climate change because I think it's going to be covered later. However, a word about the politics. Tackling climate change isn't in the interests of a lot of international investors. And resistance to tackling climate change is in the direct short-term political interests of a lot of our politicians. What TTIP and CETA will do is give them a tool to essentially stop anyone arguing against them. And incidentally, I disagree with you on the idea that economic growth necessarily accelerates climate change. I think we're just looking at the wrong type of economic growth. My first ever job, ladies and gentlemen, was working for a solar energy company in public affairs, and we passed the feed-in tariff under the last Labour government. And this created graduate jobs. It created power, and it stimulated the economy. Of course, the last government got rid of it. it depends. In terms of economics, there's a huge economic opportunity that the UK has. We could become a global centre of renewable energy because we're perfectly geographically located in terms of wind, in terms of tide, and yes, indeed, even in terms of solar, because contrary to popular opinion, solar energy doesn't just work when the sun's out. It's an economic opportunity that we are throwing away for purely political reasons.
Another? Manuel? Sorry.
Sam. Hi, Sam, Friends of the Earth. You might know me familiar. My question is, actually, so I'm going to take a bit of a contrary view. So some of the recent ISDS cases within Europe have been renewables companies suing states for removing tax breaks or tariffs. So the example would be Spain or Croatia. So could ISDS be used to promote renewables? And what effect will that have on the debate?
Sure. No, absolutely. And it's a question worth considering. As well, to begin, the first point is that my argument is that there's going to be very few renewable regulations in future on which you can base a case. However, pretty much every state in Europe has a perfectly good method for renewable companies, or indeed any other company, to take a government to court. It's called the court. And I'll give you an example of this. The company that I first worked for, once the government first tried to remove the feed-in tariff, they did it without, well, really telling anybody, and in breach of a lot of legitimate expectations. And so that company, as part of a coalition, took the government to the administrative court and won. And the government did eventually abolish the feed-in tariff, but they had to A, pay compensation, B, delay it for 2 years, and C, do it properly. So I think, I can absolutely reject the suggestion that that courts will somehow be unfair on international investors because it's the state judging its own case. If that's the case, then I mean there should be a revolution, because all of us use the public law courts to keep the government honest. And if the public law courts are just the government being a judge in its own case, then really we have an entire system, indeed a constitution, that is failing. I think if the public law courts are good enough for citizens, which in my submission they are, then they're good enough for international investors as well, and also for domestic solar energy companies.
I'm afraid we're going to have to leave it there, or the coffee will be cold. I'm sorry about that, but if you have a question you're dying to ask one of the presenters so far this morning, please feel free to buttonhole them during the coffee break, and I'm looking forward to starting up again afterwards with speech on third countries and our keynote speech. So thanks very much to all the presenters.
Steal these.
Sorry for the late start, everyone. Just a corrective. We are now breaking for 15 minutes. We're going to try to stay within schedule, so if everyone can be back in the auditorium by past. Great. Enjoy the coffee.
So, you know, he was, I mean, to be fair, I mean, they also,
Well, we want to go testimonials.
so far we didn't discuss